The court considers that the civilian population in the Gaza Strip remains extremely vulnerable.
That was Judge Joan E. Donoghue, President of the International Court of Justice, as she read the court's order Friday in reply to an application by South Africa for provisional measures to force Israel to stop its war on Gaza until the underlying case charging Israel with genocide can be heard by the court.
It recalls that the military operation conducted by Israel after 7 October 2023 has resulted inter alia in tens of thousands of deaths and injuries and the destruction of homes, schools, medical facilities, and other vital infrastructure, as well as displacement on a massive scale. The court notes that the operation is ongoing and that the Prime Minister of Israel announced on 18 January 2024 that the war, I quote, will take many more long months, end of quote. At present, many Palestinians in the Gaza Strip have no access to the most basic foodstuffs, potable water, electricity, essential medicines, or heating. The World Health Organization has estimated that 15% of the women giving birth in Gaza Strip are likely to experience complications and indicates that maternal and newborn death rates are expected to increase due to the lack of access to medical care. In these circumstances, the court considers that the catastrophic humanitarian situation in the Gaza Strip is at serious risk of deteriorating further before the court renders its final judgment.
The judges ordered Israel to not kill any civilians in Gaza and to not commit a number of other acts that violate the genocide law, but it stopped short of imposing a complete stop to military action in Gaza. The court did deny Israel's attempt to have the case dismissed. In a press conference immediately after the order was released, South Africa's Foreign Minister, Naledi Pandor, spoke with reporters.
This case was very much about international bodies ensuring that they exercise their responsibility to protect us all as global citizens. All member states of the United Nations have attached their signatures to a range of instruments. But when lives are threatened, these instruments are not brought to bear. And South Africa had the view that we could not stand idly by and continue to observe the killing of thousands of Palestinian citizens who had no role in the awful act of hostage-taking and killing that was done by Hamas. And therefore, we thought it important that we do report and apply to the International Court of Justice that the measures provided within the Convention for the Punishment and Prevention of Genocide are brought to bear, and that the State of Israel is called upon by the judges to act to protect civilians and to end the massive level of harm that we have seen since the Israeli action began. And we agree entirely with the judges that Hamas should release the hostages that they're currently holding. We also, in our various engagements with our partners internationally, believe the moment is now ripe for there to be negotiations for a two-state solution to end this conflict decisively.
Minister, are you disappointed there wasn't a ceasefire? Are you disappointed the court didn't call for a ceasefire?
I believe that in exercising the order, there would have to be a ceasefire. Without it, the order doesn't actually work. I would have wanted a ceasefire.
They didn't specifically call for a ceasefire.
No, they didn't.
Are you disappointed that they didn't specify that in their provisions?
I have no way that I'm going to say I'm disappointed. I hoped for it, but the fact of delivering humanitarian aid, the fact of taking measures that reduce the levels of harm against persons who have no role in what Israel is combating, for me, requires a ceasefire. And I believe Israel would have to attend to how it conducts its search for the hostages and for those Hamas individuals who carried out the October 7 attack.
Well, to try to make sense out of all of that, we speak with Christopher Black, who's an attorney who's practiced in front of the ICC, and we've spoken with him before about this case. which is before the ICJ. Chris, your thoughts on first blush looking at this decision today?
It's a display of blatant display of double standards, because on March 16, 2022, when Ukraine made a complaint similar to the South African complaint against Russia, the court quite quickly issued an order compelling Russia to withdraw its forces from Ukraine and stop its operations. At a point when no civilians had been killed on anybody's account at that point in March of 2022. And yet, when the whole world sees Israel committing genocide against the Palestinians in Gaza, and when the court recites evidence that South Africa presented to them in its decision, which are compelling evidence that that's still going on, did not make an order that the South Africans requested for a ceasefire and for them to withdraw their forces. They just said, you can keep the war going and basically just behave yourselves, boys. That's all they did. So they basically gave a green light for those operations to continue. And the South Africans claim that's a victory, that they made this order compelling Israel to obey the Geneva Conventions, but Israel already states that it's doing that. It is somewhat of a success that Israel has been told that there is maybe a plausible case that they're committing genocide, which will be heard later on and sometime in the future in the court when the substantive case is argued. That's some accomplishment, but it doesn't do anything to stop the operations that Israel is committing, and doesn't make or require Israel to stop those operations yet. As we saw just 18 months ago, Russia was ordered to stop its operations by the same court. So the display of double standards is quite clear.
We have a 29-page document. And when the court is getting to the point after reciting the history and its position on various issues, that in essence, that the litigation is going to go forward, that there is a plausible case and other things, before it actually gets to the meat of the determination, it throws in this statement about the hostages, as they're termed, the people that are being held prisoner by Hamas. It is gravely concerned about the fate of the hostages abducted during the attack in Israel on 7 October 2023 and held since then by Hamas and other armed groups, and calls for their immediate and unconditional release.
All right.
There's nothing comparable to, let's say, first of all, being gravely concerned about the 30,000 people that have been killed now in the last 3.5 months, and particularly 10 or 12 or 15,000 children. And then, of course, if you want to term these people hostages, what do you term all those people that are in Israeli jails? And how many are there?
Oh, estimates go from 15 to 20,000, and including many thousands of children, and some born in prison, to women being held there without charge or without conviction, and being basically held hostage for many years. And the court didn't mention them at all. And yet that's one of the reasons that Hamas acted. I mean, that's just ignored.
I mean, this is something that's been going on, right? Trading hostages, so to speak. Right. Yeah.
Right.
Only it's so out of scale. You've got 10 or 15,000 people on one side, and I don't know how many are left supposedly in Hamas's custody. 50,
maybe 100, maybe 150 left. I think half have been released, but I think they still have. I think it's around 150, something like that.
So it's like 100 to 1 in this.
Yes, 100 to 1, so they implicitly accepted the Israeli argument that they're acting in self-defense, when the court should have stated quite clearly, in accordance with UN resolutions and the ICC decision, and even one of their own decisions, that Israel has no right of self-defense against the Hamas operation on October 7th, because the Hamas was acting as a legitimate resistance group, attacking the military forces of an occupying power, occupying its lands, their lands. Israel has no right of self-defense against such a military action. Their only legal option is to withdraw their forces from the occupied territories. Yet the court ignored that and implicitly accepted that Israel has the right to self-defense, therefore can continue the operation, when they should have said Israel has no right to continue this operation or even begin this operation. That was never said.
Yeah. Now the underlying case goes forward, is that?
Yeah, the basic substantive case about whether Israel has committed genocide or not, and on the evidence will be heard at some future date unknown to us, months or maybe even years in the future, but well after this war is concluded, probably.
And before they exhaust the bodies of every remaining person in Gaza, there's this, in essence, a 30-day reprieve on the injunctive relief. They're supposed to submit some kind of a report showing how they've stopped doing whatever bad things they might have been doing that they haven't really been found to be doing by the court.
Exactly. It's sort of Alice in Wonderland. So Israel may never file such a report, or it'll get lost in the bureaucracy of the ICJ or the UN somewhere, or they may file a report claiming that they're doing exactly what they're supposed to do. But that won't probably be filed in evidence until the substantive hearing takes place, whenever that does.
Gotcha.
So,
okay. Thank you very much. Appreciate it.
You're welcome.
For KPFK, I'm Don DeBar.